Just delete it can cost you the case. Spoliation of evidence in Utah. People in divorce and child custody disputes often think that the safest move is to delete anything that looks bad. Texts, emails, social media, financial records. That instinct is understandable, but it's a mistake. In Utah, this is called spoliation of evidence. It means destroying or failing to preserve evidence that is relevant to a legal dispute. You don't have to preserve everything in your life forever, but once litigation is filed or reasonably anticipated, you do have a duty to preserve relevant material. That's where people get into trouble. They start cleaning things up right when the law requires them to stop. Courts take this seriously. A judge can assume the missing evidence would have hurt you, prevent you from introducing your own evidence, order you to pay the other side's fees, or decide key issues against you. In a divorce or child custody dispute, credibility matters. If a judge believes you deleted evidence, everything else you say is harder to accept. In some cases, this can also cross into criminal territory if the conduct is intentional. The practical point is simple. If there is damaging evidence, deleting it usually makes things worse. Judges deal with imperfect behavior. What they don't tolerate, well, is concealment. If you're dealing with a bad fact, the better approach is to address it, put it in context, explain it, deal with it directly. Once evidence is gone, you don't get that opportunity back.